Good morning, everyone. Hope everyone's well today.
Good morning.
Morning, Judge.
Good morning, Judge.
Where are we going to start this morning?
Good morning, Judge Morrow. This
Good
is
morning.
courtroom 2 with positions 26 and 27. Mr. Darrell Scott.
So position 26 is a plea, and position 27 is going to be arraignment and a bond hearing. Is that correct?
That's correct, Judge.
Good morning, Mr. Scott. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning. Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down, Mr. Scott. I'm going to start with the arraignment first. It's position 27, case 20 CR 003268Y, simple battery, family violence. Mr. Scott, this charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation? Ms. Helen,
I do, Judge.
how do you plead, Mr. Scott, guilty or not guilty?
Guilty.
It's my understanding that you're going to plead not guilty to this simple battery today, Mr. Scott. Is that not correct?
He may not know which one you're referring to, Judge. Mr. Scott, position 27, the simple battery with dad.
Oh, well, I will plead not guilty.
Okay, thank you. We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Mr. Taylor, good morning. Are you presenting for the state on this case?
Yes, Your Honor.
Okay, you can proceed.
All right, and this is for the simple battery case, or?
Position number 26, simple battery, obstruction of an officer, and simple assault, I believe.
Oh, no, Judge, we're on 27 for the bond hearing if we're doing that.
We're gonna do the bond hearing last. I want to get the plea
Okay.
out.
Understood, Judge.
All right, Your Honor, Mr. Scott's charged with simple battery, family violence, obstruction of an officer, and simple assault. The plea recommendation in this case is to plead to count 1, simple battery, family violence, for 12 months probation, credit for time served 3 days with the balance probated. He's to take a FBIP course, to have no violent contact with the victim in the case, Lashunda Woods. And he's to plead to count 2 for a $300 fine, 12 months probation to run concurrent with count 1. And the final 12 months can be suspended upon completion of the terms.
Are you gonna non-plus the simple assault?
Yes, Your Honor.
Have you gotten that non-pros to the court?
I have not yet.
Ms. Helen?
Yes, Judge, this is our understanding of the plea. We do stipulate to the factual basis, venue, and ID. It's a probated sentence, so Judge, we're asking for all of those probation fees to be waived for Mr. Scott. And we're asking, yes, that this court go towards non-reporting after he completes the conditions.
Any objection to non-reporting, Mr. Taylor?
I don't have any objection to the final 12 months being non-reporting. I would object to the first 12 months being non-reporting.
Okay. Mr. Scott, it's my understanding in case 18 CR 006231Y, you wish to plead guilty to simple battery, family violence, and obstruction of an officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Absolutely. Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea as negotiated, Mr. Scott. I'm going to waive the probation fees for you while you're on probation. You'll be on probation the entire first 12 months. Once you complete the terms of the probation, it can go to a non-reporting status. Okay.
Yes, sir.
All right. Let's move on to the position 27, the bond hearing on this matter. What's his current bond?
It's a $1,000 cash bond, Judge.
Do we have his history?
He has 9 cycles. He has a total of 3 FTAs, 2 from this year and 1 from 2021. He has a 2021 battery family violence conviction out of Henry County. And a 2000. Sorry, Judge, I didn't hear you.
Okay, this is a bond. Thank you, Ms. Roberts. Ms. Helen, you understand how I feel about these. This is a bond forfeiture case. It came from who? Judge Edie. So it's going to have to go back to Judge Edie if you want to modify that cash bond.
Understood, Judge.
Good luck to you, Mr. Scott.
Mr. Scott, let me explain. The judge stated this is going to go back to Judge Edie for that bond hearing because Judge Edie made that modification to cash, okay?
Okay, who do we have next?
I don't know what I see, Judge Edie.
Say it again.
When I see that, Judge. Judge
I'm
Edie.
sorry, I can't hear you.
When would I see Judge Edie?
Ms. Helen, I'm not sure when the Judge Edie's next hearing date is, but you can have Ms. Helen check for you and she'll get with you.
And I can give you a call, Mr. Scott.
All right, thank you.
Thank you.
Ms. Lewis is in court with me today, so if you all will get all the paperwork to her so that we can get that signed.
Williams. Positions 42, 43, Williams.
Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning.
Good morning, sir. And you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. One is negotiated and one is not negotiated. Is that right?
That is correct, Judge. Position 42 is negotiated. Position 43 is non-negotiated.
All right, Mr. Taylor,
Yes, Your Honor. Well, which one did you want to handle first?
let's just go in order 42 first and 43 second.
All right. In position number 42, Mr. Williams is charged with 1 count of criminal trespass. Plea recommendation is as follows: 12 months to serve 32 days, credit for time served 16 days, with the balance suspended, and he's to stay away from the incident location, which is the Bankhead MARTA station.
You know the address for the Bankhead MARTA station?
I can look that up real quick. It is 1335 Donald Hollowell Parkway. And that's in Atlanta, Georgia.
Thank you. Yes, Judge, that is our understanding of the this time served, balance suspended plea. And we do stipulate to the factual basis, venue and ID.
Thank you. Position 43, Mr. Taylor.
Yes, Your Honor. In this case, Mr. Williams was charged with 1 count of simple battery. The plea recommendation that we suggested in this case was 12 months to serve 90 days to run concurrent with the case that he is entering a negotiated plea to. Credit for served for 9 days, 6 weeks of anger management classes, and no contact with the victim in the case, Marlene Edwards. Did you want to hear a factual basis in this case, Your Honor?
Yes, please.
The facts in this case is the victim was at the defendant was at the 5 Points MARTA station and entered into a train. The victim was sitting in her seat on the train. The defendant stood in front of her and punched her in the face. It's my understanding that they do not know each other. He was immediately recognized by the MARTA police officers due to his frequent run-ins with the officers there at the 5 Point station, which he frequents.
What's his history, Ms. Roberts?
43 cycles. He is currently on probation, 22 CR 004028J. Disposition date was June 30th, 2022, 12 months probation. I'm going to waive the sounding of the charge. He has a criminal trespass conviction from 2015, a criminal trespass conviction from 2016, a willful obstruction conviction from 2016, 2 disorderly conduct convictions from 2017. He has a 2017 possession and use of drug-related objects and possession of cocaine conviction, a FTA from 2016, a possession of cocaine conviction from 2018, a purchase, possession, or have a control substance in Schedule 1 or narcotic in Schedule 2 conviction 2019, a possession of cocaine conviction from 2019. He has 3 other convictions similar to the probation, 2 in 2016, 1 in 2019. A obstruction conviction from 2019. And nothing further to add.
Thank you, Ms. Roberts. Ms. Helen.
Judge, we're asking for 45 days to serve with the probation, with the conditions. I believe that'll be 7 additional days for Mr. Williams. He understands that he wants to resolve this case. So that is why he's agreeing to the probation. He agrees that he did something wrong, Judge. But we are just asking for the 45 days to serve instead of the 90 days, Judge. Oh, and correction, I have credit for time served 16 days. I have that he's been incarcerated since October.
Any objection to giving him 16 days credit for time served on the simple battery, Mr. Taylor?
No, Your Honor.
All right. Mr. Williams, it's my understanding that in case 22 CR 007144J, you wish to plead guilty to criminal trespass. And in case 22 CR 007382J, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yeah. No,
You don't want a jury trial, do you?
no,
Has anybody forced you or coerced you to plead guilty?
no,
I'll accept on position 42, the criminal trespass. I'll accept the plea as negotiated. And position 43, the non-negotiated plea to simple battery, it's going to be 12 months to serve, 90 days, credit for time served, 16 days, balance probated, a 6-week anger management class, and no further contact with Marlene Edwards. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet, but I'm going to require that you be on probation for the entire 12 months.
okay.
Good luck to you, Mr. Williams.
I'll see you too.
Position 7, Mitchell.
Is that on the add-on calendar?
Yes, it is.
Okay, so he's also, I believe, position 6 and 7, Judge.
So these are going to be arraignments and bond hearings.
That's correct, Judge.
Good morning, Mr. Mitchell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Ricky, come on. You talk already.
Was that a yes, sir? You want?
Yes, sir.
Okay, thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Mitchell, you've been charged in case 22 FTA 000018 with failure to appear for fingerprintable charge. And in case 22 CR 004576H for battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you wait for the reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Mitchell? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Do we have his bonds?
This is a bond forfeiture also, that's why you have the FTA on the calendar, they start getting anything.
I have that the bond is a $5,000 surety bond.
Is it, who issued the bond?
Judge Taylor.
Okay, you understand how I feel about this, Ms. Helen. It's going to go back to Judge Taylor if he's going to modify his bond.
Understood, Judge.
All right, good luck to you, Mr. Mitchell.
Position 31, Taylor.
Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor. How you doing, Your Honor?
I'm doing well, Mr. Taylor. I hope you are too. Mr. Taylor, you've been charged in case 22 CR 007141E with criminal trespass. Can you raise your right hand for me?
Yes, Your Honor.
Okay, go ahead and do it. Do you, okay, do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Right. Yes, Your Honor.
Okay, thank you, Mr. Taylor. You can put your hand down.
Yes, Your Honor. In this case, Mr. Taylor is charged with 1 count of criminal trespass. The plea recommendation is credit for time served, 12 days. Sorry, 12 months probation, credit for time served, 12 days with the balance suspended. He is to stay away from the incident location, which is the Lenox Square Shopping Center, located at 339 Peachtree Road Northeast.
Yes, Judge.
How much time is he, I'm sorry, how much time is he served?
I
It's
have
18 days, Judge.
Okay, thank you. Go ahead, Ms. Helen.
Yes, Judge, that is our understanding of the plea with just the correction of the credit for time served is 18 days. And we do accept that plea and we do stipulate to the factual basis, venue and ID, Judge.
Mr. Taylor, it's my understanding that in case 22 CR 007141E, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor. Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor. I don't use drugs.
Okay, all right. Thank you, Mr. Taylor. You've been represented by Ms. Helen. Are you happy with her representation?
Yes, Your Honor. Yes, Your Honor.
Okay, you understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury?
Right, Your Honor. Yeah.
Nobody's forced you or coerced you to plead guilty, have they?
No, Your Honor.
Okay, so I'm gonna accept your plea as negotiated, Mr. Taylor. You realize you can't go back to Lenox, okay?
Yes, sir. Yes, Your Honor. All right.
All right, good luck to you, Mr. Taylor.
Thank you, Judge.
Ms. Darling, did y'all know that the
Position 30, Talbot.
last case we did, we also on the regular count for position number 17, that did not address that. These are the count. Position 17, we want the judges to, prior to this last one, Mr. Mitchell. Okay, nobody said anything about 17.
Do we still have Mr. Mitchell in courtroom too?
Yes.
Can we bring him back up, please?
Mr.
Thank you.
Mitchell,
Are you representing him on this, Ms. Helen?
Yes, Judge.
And what do we, it says hold for announcement. What are we doing?
Judge, we're gonna arraign this case, Judge.
Okay. Mr. Mitchell, you are still under oath. And in this case, you have been charged in case 22 CR 007146H with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do.
How do you plead to this charge, Mr. Mitchell? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea and your case will be returned to the division judge for, and you'll get notification of the next hearing date, okay?
Yes, sir.
All right, thank you, Mr. Mitchell.
Yes, sir.
position 30, Talbot.
Okay, thank you. Arraignment and bond hearing.
That's correct, Judge.
Good morning, Mr. Talbot. I'm Judge Eric Morrow. This is the state court all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Is that a yes?
Yes, sir.
Okay, thank you. Mr. Talbot, you've been charged in case 20 CR 0007885B with possession and use of drug-related objects, simple battery against a police officer or detention officer, and littering. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Talbot? Guilty or not guilty?
I'm guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Say it again.
The bond forfeiture case,
Okay, from,
Judge Porter, he brought to you there.
okay. Is it also an FTA, Ms. Helen, from Judge Porter? So it'll be returned to Judge Porter if you wish to have the bond modified.
Understood, Judge.
Good luck to you, Mr. Talbot.
Position 18, Nice.
This is just an arraignment. Is that correct? Who's representing Mr. Denise?
I believe that's Mr. McCain. What position?
Good morning, Your Honor. Mr. Neese is my case.
Okay, good morning, Mr. McCain. This is just going to be an arraignment, is that correct?
That's correct. His mom is going to try to make his bond if the court, let's see. I realize there's certain policies under which the court feels that it is not appropriate to approach the bond for a reduction if one of the trial judges had set it in a failure to appear mode, or if Your Honor had said it and there's not a change in circumstances. I understand those are the two circumstances that it would not be appropriate for him to ask a bond reduction, if I'm correct. But he is going to have his family try to make the bond, and he is pleading not guilty today.
Okay, so he didn't fail to appear. This bond was set by Judge Mincy back in October. $3,000 good bond for the first charge and a $500 good bond for the possession of marijuana. I'm happy to hear you on it if you want to speak to it after I arraign him, Mr. McLean.
Certainly. Thank you.
All right. Good morning, Mr. Neese. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Neese, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Neese. You've been charged in case 22 CR 007343F with one misdemeanor offense and possession of marijuana less than an ounce. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Neese? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Ms. Roberts, is there a history?
Judge, I missed this position number. What was the name?
18, Mr. Neese.
You said 18?
Yes, ma'am.
Okay, give me one second. My computer is not responding for the GCSEs. It's not pulling out.
Good morning, Ms. Sawyer. How are you today?
Good morning, Judge. I'm doing well. How are you?
I'm doing well, thank you. Do you have his history?
Yes, Your Honor. This defendant has a 2020 battery. It looks like it's open or there's no disposition out of Dorville. And he has a criminal trespass that is open in DeKalb. Your Honor, the facts of this case is that the victim, whose name is Sakythia, that's Sakytia, last name Pitts. She was riding the MARTA train and the defendant was also. The defendant came and sat in front of this victim. He then turned around to blow kisses at her and asked if she wanted to make some quick money. The defendant or the victim said no, and she continued texting on her phone. And that's when the defendant exposed his genitals to this victim. I would like the court to note that in the MARTA report, it does state that the defendant is a registered sex offender, and he was given a permanent ban from MARTA. So the state is recommending, due to the nature of this incident and his history, that the bond remain as set, with conditions of course, complying with the MARTA suspensions, no contact with this victim, and nothing further, Judge.
All right. Mr. Jordan, are you there?
I think it's, what you mean? I'm co-host. I can put you on the breakout room.
Okay. Mr. Walker, Ms. Sorry, Mr. McLean, I'd like to go into a breakout room, please.
Okay.
Okay, we've had a discussion on Mr. Neese. I'm not going to modify the bond at this point in time. Good luck to you, Mr. Neese.
I'm muted, I'm sorry. Let me just announce, Your Honor, in Neese's case, that his family will try to make his bond, and I will advise him or have another public defender go to the jail and advise him of the possibility of another bond hearing in the future if it's appropriate.
Okay, so advised. Who do we have next?
Got position 24.
And this is a negotiated plea.
Yes, Judge.
Okay, my calendar does not have a name for position 24. Could someone please give me the name?
Rico Rogers.
Rogers, common spelling.
Okay, thank you. Good morning, Mr. Rogers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? You have to answer yes or no.
Oh, yes.
Okay, thank you, Mr. Rogers. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Rogers. Mr. Taylor?
Yes, Your Honor. In this case, Mr. Rogers is charged with 1 count of criminal trespass. The plea recommendation is 12 months to serve 30 days, credit for time served for 15 days, the balance suspended, and he is to stay away from the incident location located at 350 Lanier Street, apartment D4.
Yes, Judge, that is our understanding of the plea. We do accept that on behalf of Mr. Rogers, and we stipulate to the factual basis, venue, and ID.
Thank you, Mr. Rogers. It's my understanding that in case 22 CR 00734-6D, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Oh, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Said again, I couldn't hear what you said.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
Now, you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Rogers. Good luck to you, sir.
All right, thank you.
You're welcome.
Positions add on 1, 2, and 3, Mr. Ferguson.
I'm being told that Mr. Ferguson's cases were being sent back to who? Judge Edie. Is that not correct?
I believe Mr. McCain has positions 1 through 3 on the add-on calendar.
Okay, Mr. McLean. Mr. McLean. Mr. McLean.
I'll give him a call, Judge.
Hold on. Thank you, Your Honor. I was just on the phone with Ms. McLeod. What
Okay.
number, Your Honor?
We are on add-on 1, 2, and 3. Mr. Ferguson, I'm being told that he is supposed to go back to, is it Judge Edie?
Yes, sir.
Judge Edie's court.
That's what I understand, Your Honor.
Okay, so Mr. Ferguson, you will be seen in the future by Judge Edie. We don't need Mr. Ferguson this morning. Thank you.
Excuse me, sir.
Yes.
I've been calling, I've been sitting in here a whole year on the misdemeanor, and I called my attorney, and she told me that I should be able to go to court today. We were talking about a plea and trying to get me up out of here today because I've been locked up for a whole year.
Who's your attorney, Mr. Ferguson?
Julia Holly.
Who?
Julia Holly.
She's the public defender with Judge Edie.
Okay, so you'll be seeing her in Judge Edie's courtroom, Mr. Ferguson. She'll be in touch with you, okay?
All right.
All right. Thank you, sir. Who do we have next?
Oh, Your Honor, while I'm on, could I make an announcement, interject one?
Yes, sir.
There is a Miss Butler on the calendar. Miss McLeod has recently represented Miss Butler on another matter. I think that with her familiarity and trust and rapport that they've built, it would be appropriate on today to have Miss McLeod represent Miss Butler on one case that's on the calendar and another case that's not actually on the calendar, but it is being proposed for a plea bargain.
So she is already representing him on that other case?
She had recently represented Miss Butler on something else, and it would be more efficient and quicker for them to talk than for me.
So you haven't spoken to Ms. Butler?
Correct. I believe that's correct. I mean, I spoke to several people in South Annex on phone this morning, and that was fruitful, but I don't think Ms. Butler and I, either she was not on the phone, she might have been the second person, but we did not get a chance to see her yesterday.
Okay. Hi, good morning, Ms. McLeod.
Good morning, Your Honor. I
So you-
represented Miss Butler when she appeared on the SEA calendar a few weeks ago, and we had a chance to talk at this time.
Okay.
At that time.
That's fine with this court, Ms. McLeod. So once we have I guess she's at the South Annex, so you need time to talk to her?
Yes, I will call the South Annex, Your Honor.
All right.
I need to communicate the plea offer to her.
Very good. Thank you, Ms. McLeod.
You're welcome, Judge.
Thank you, Your Honor.
You're welcome. Who do we have next?
Positions, this is Mr. Chavez, position 4 and position number 37.
4 and 37.
4, 6, and 37.
Your Honor, on 4, 6, and 37, I had heard that his mother had a program lined up for him, and the program sounded like it wouldn't be that different from what the state was interested in. I was gleaning what I thought the state might be interested in the one of the 3 cases in which they did not make an offer. I was looking at their other offers on the other 2 cases and thought, well, this very well could line up. So I got hold of the mother, and there is a language barrier. We're going to need an interpreter. I did manage to ask the mother if the program of which she was speaking was ready. And I hoped the answer was yes, but she said it's going to take another week. I'm disappointed in that, but I think we're going to need a Spanish interpreter to have her on Zoom to talk about what she has in mind. And that would, if I ask for the court for another week, I hate to do that, but that would give us time to communicate with the mother better, which today was the first time we finally reached her, and see whether or not the state is thinking the way I'm thinking, given their other offers.
Ms. Sorry, is this your case? Are these
Yes,
your
Your Honor,
cases?
it is.
On position 4, I've got no offer. Why is that?
By operation of law, Your Honor, he does have a theft by taking conviction. One of the other cases is a theft by taking, which we've offered a plea. So for that second one, or the third one, it would be a felony by operation of law. However, we will entertain Mr. McLean's his thought at this point. So we are okay with that reset.
Okay, Mr. McLean, is there any way that you can get an interpreter to speak with his mother before next week so that we can move this case forward?
Come Hades or high water, Your Honor, I will figure out a way to do that.
Okay, I appreciate that, Mr. McLean, because if you can speak with her before then and get in touch with Ms. Sorry when you all come back, because we put Mr. Chavez Vasquez off for a couple of weeks now.
We've done that.
If you all can resolve that by next week, I'd appreciate that. So I am gonna give you all another week to work this out. So 8:15 reset for Mr. Vasquez Chavez. Okay, so Mr. Vasquez Chavez, I'll see you back next week, sir. Okay. All right, thank you. Who do we have next?
The South Annex, position number 41, Brianna White.
I'm sorry, South Annex, tell me. Who is this?
Position 41, Brianna White. Good morning, Your Honor.
Good morning. Position 41, Brianna White.
That's a negotiated plea, Judge.
Okay. Good morning, Ms. White. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning. Good morning, Mr. Taylor.
Good morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, ma'am. Mr. Taylor.
Yes, Your Honor. In this case, Ms. White's charged with 1 count of simple assault and 1 count of simple battery against a police officer. The plea recommendation is as follows: to plead to count 1 for 12 months probation, serve 20 days credit for time served, which is 23 days at this point, 30 hours community service, 6-week anger management class, stay away from the incident location, MLK Grocery, located at 3665 Martin Luther King Jr. Drive. No contact with the victim in the case, Patrick Lucky. And she is to plead to count 2 for 12 months probation to run concurrently with count 1.
Yes, Judge, that is our understanding of the terms of that plea. We do stipulate to the factual basis, venue, and ID. This is a probated sentence, Judge, so we are asking for those probation fees to be waived. And if the state is amenable, if it can be non-reporting once she completes those conditions.
Any objection to non-reporting, Mr. Taylor?
No objection, Your Honor.
Ms. White, it's my understanding that in case 22 CR 007329G, you wish to plead guilty to simple assault and simple battery against a police officer. Is that correct?
That's correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
I'm not under influence, Your Honor.
You can represent it by counsel. Are you satisfied with her representation?
I'm satisfied with the representation, Your Honor.
You understand that you have a right to a trial by jury on these charges, and not by pleading guilty to them. You're giving up your right to a trial by jury?
I do have understanding that.
Has anybody forced or coerced you to plead guilty?
No, man.
Okay, I will accept the plea as negotiated, Ms. White. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And as soon as you complete the terms, it'll go to a non-reporting status, okay? All right,
Thank you,
good luck
Judge.
to you, Ms. White.
Thank you.
All right,
Yeah.
who do we have?
Position 11.
Position 11. Okay.
Your Honor, on position 11, normally that would be my case, the way we split the calendar up. However, from my representation in my trial courtroom about 1.5 years, 2 years ago, I recognize the parties' names. I remember our position in that case, and that would be a conflict for us to represent him.
Okay, do we still have Ms. McLeod on the line? Ms. McLeod? Okay, I'm sorry. We're gonna have to, Mr. Howard, we're going to have to wait till we can have Ms. McLeod speak with him. Is there any way that she can get in touch with him when she is available?
She should be logging on soon, Your Honor, because she was speaking to Ms. Butler here at the South Annex.
Okay, she's already logged on. I see her here. I'm just not getting any response from her.
While we're waiting, can we just go to another position?
Yes. So if you'll hold on for me, Mr. Howard will be back with you. Who do we have next?
Position 13, Love.
Oh, here we go. Ms. McLeod?
Yes, Your Honor.
They are requesting on position number 11. There's a conflict with the public defender. Is it possible for you to talk with Mr. Howard in regards to this matter this morning?
Yes, Your Honor.
Okay. How do we get in touch with Mr. Howard? Is there a way to do that?
She would have to give me her number. We have to give her a call.
All
I
right.
can put my number in the chat.
Okay, if you all will make that happen for us. Thank you. Thank you, Ms. McLeod. All right, I'm sorry, courtroom 2. Tell me where we are again.
Position 13, Love.
That's a negotiated plea.
All right. 13. Good morning, Mr. Love. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning, Judge.
Good morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sure.
Okay, thank you. Ms. Story.
Yes, Your Honor, the state's offer in this case is 12 months to serve 30 days, credit for time served 15 days, the balance probated, an FBIB course, no contact with the victim whose name is Timothy Wright, and to stay away from the incident location, which is 2301 Godby Road in College Park. Nothing further, Judge.
Okay. All right. Mr. McLean.
Your Honor, the client and I ran over everything yesterday, and he wishes to ask the court to accept the negotiated plea.
Okay, and I have been told that Mr. Wright is on the line. Mr. Wright, you are not required to speak. If you would like to address the court, now is your opportunity to do so. If that's the case, you'll have to unmute yourself and activate your camera, and I'll have to swear you in. Again, you do not have to if you choose not to. Okay, I'll give Mr. Wright the opportunity. It does not appear that he wishes to address the court. Mr. Love, it's my understanding that in case 22 CR 007341G, you wish to plead guilty to battery family violence. Is that correct?
Yeah, what did she say again? Because I was told that I won't have to serve no more jail time.
The offer that they've agreed to, Mr. Love, is 12 months to serve 15 days, credit for time served, credit to serve 30 days, credit for time served 15 days. So we're 2 for 1. If you don't have anything else holding you, you should be getting out of custody as soon as the jail can process you out. Was that your question?
Yeah, that answered my question.
Okay, very good. So it's my understanding that you wish to plead guilty to battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Sure.
Is that a yes? I'm sorry. Are you satisfied with his representation?
Sure.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up your right to a trial by jury?
Sure.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated. I'm going to waive the fees for you, Mr. Love, to help you get and stay on your feet. And was there a request as far as Mr. McLean, was there a request as far as once he completes the terms?
Your Honor, it would be appropriate if once he completes the terms, if it could go to terminated, suspended, or non-reporting. I don't think there's going to be any problem between these folks. It would also be appropriate if his belongings are able to be packed up in a box to have one visit with the police escort to get his belongings.
Any objection to non-reporting, Ms. Sari?
No, Your Honor.
All right, so it'll go to, I'm going to waive the fees. It'll go to a non-reporting status, and he can return to 2301 Godby Road on one occasion with the escort of law enforcement to retrieve any belongings that he may have there. Okay?
Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Love.
Position 35, Tucker.
That's a negotiated plea, Judge.
Thank you, Ms. Helen. Good morning, Mr. Tucker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Good morning, Your Honor. Yes, I agree.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Put your hand down. Thank you, sir. Mr. Taylor.
Yes, Your Honor. In this case, Mr. Tucker is charged with one count of loitering and prowling. The recommendation is 12 months probation, credit for time served, 8 days with the balance suspended, and to stay away from the incident location at 1087 Lindridge Drive.
And Judge, just with the update of the days of confinement being 14 days, that is our understanding of that plea offer. We do stipulate to the factual basis, venue, and ID.
Mr. Tucker, it's my understanding that in case 22 CR 007347E, you wish to plead guilty to loitering and prowling. Is that correct?
Yes, that's correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, not at all, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Tucker. Good luck to you, sir.
Same to you and the rest of the court. Thank you, Your Honor.
Thank you, Judge.
Position 38, Veal.
Arraignment and a bond hearing.
That's correct, Judge.
Mr. Veal, good morning. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? All right, Mr. Veal, you've been charged in case 22 CR 007142B with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you wait for a reading of the accusation?
I do, Judge.
It's not okay. Mr. Veal, how do you plead, guilty or not guilty?
I know I spoke with my attorney yesterday and I was going to plead not guilty, but to get the case resolved, I want to plead guilty.
Well, Mr. Veal, let me give you a call so we can talk about that because we're going to come to a decision, okay? Judge, if I could be given an opportunity to call Mr. Veal and we can take another case or.
Okay, that's fine with me, Ms. Helen. Do we have a case that's Mr. McLean that's ready in courtroom 2 and or wherever?
Mr. Bodie, positions 1 and 2.
Okay. And this is also going to be an arraignment bond hearing.
Correct, Your Honor.
Good morning, Mr. Bodie. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, sir. You have been charged in case 22 CR 007148E with battery family violence and in case 22 CR 007159E with battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you wait for a reading of the accusation, Mr. McLean?
We do. We had copies and read them.
All right. How do you plead, sir? Guilty or not guilty?
Not guilty.
We record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. I set these bonds back on October 24th. Each charge with a $15,000 good bond. Has there been a change in circumstance, Mr. McLean?
I cannot say there has been, Your Honor.
Okay, this seems to be a high bond of for myself, so I am certain that there must have been some underlying reason for it without there being any change in circumstance. I'm going to leave the bonds where they are. Good luck to you. sir.
Understood. I'll so advise him.
Who do we have next?
I got position 11 here, Judge.
Okay. So we're going to go back to Mr. Howard. Have we had an opportunity to speak on that matter? Ms. McLean?
That 11 is Mr. Howard with Ms. McLeod now. That was the conflict I discovered.
Right, right.
Yes, Your Honor. I was able to speak with Mr. Howard.
And what are we going to do with him?
He wants to accept the state's offer, Your Honor.
Okay. Good morning, Mr. Howard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're doing by video. Do you agree to have your case heard by video?
Yes, sir. Good morning, Judge. Yes, sir.
Good morning. Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Ms. Sorry.
Yes, Your Honor, the state's offer in this case is 12 months to serve, 90 days, credit for time served, 16 days, the balance probated, an FFIB course, no contact with Jada Carter, and third-party transfer of their minor child, and to stay away from the incident location, which is 1773 MCCLELLAND Avenue in East Point. Nothing further, Judge.
Ms. McLeod?
Yes, Your Honor. My understanding is that my client has been actually in jail since 2020. So I'm not sure about the 16 days since he's been in jail since 2020. So I was under the impression this is going to be a time served since he had been in jail since 2020. I thought that was just a typographical error, the 16 days.
He's been in jail for, he's been in jail for 13 days. Booked in October 27 and 22. It looked like he's a CPO from the corrections facility of Riverbend. So he's to return back there once he completes all his charges with Fulton County. So he is incarcerated.
Did you hear that, Ms. McLeod?
No, I did not hear any of that.
Okay.
This is Katrina. According to his booking screen, he's a CPO. He's over on charges for Fulton County. He's being retained at a prison at Riverbend Corrections Facility. So once he gets done with all his charges here at Fulton County, he will return back over to that facility. So he was booked in on October 27 or 22 for these charges, and along with his felony charges, I guess, for a hearing. And they saw these charges, so they went on board and put these charges on him. So he's only been at the Fulton County Jail for 13 days. True enough, he may have been incarcerated in another facility for a year, but he's only been in our facility for 13 days.
Okay, so he will be going back to the facility.
Yeah,
you're saying?
Yes.
Okay.
CPO.
Well, he's okay with it as long as he's not going to do additional time.
Well, he will be doing it. Technically, he will be doing additional time. I'm not sure how much more time he has at the prison level, but as far as this case is concerned, if he accepts the offer, it's going to be 90 days credit for time served, 16 days. But if he's already in jail and he won't be able to get out, I'm sure that time will run at the same time.
Right. I just want to make sure it's going to run concurrently, Your Honor, because he does tell me that he's going to be in there. He is in there on another case and expects that he will be there for at least another 90 days. So he's okay with that. With respect to the balance on probation, Your Honor, we were wondering if the court would waive his probation fees because he's not out and working. So when he gets out, he will not be able to pay fees. And also the child is not his child, so he really doesn't have any visitation rights.
Okay.
So that doesn't need to be in the order.
Okay. All right. Anything further before I take the plea? I know that Mr. Howard had his hand up. You still have a question for Ms. McLeod, Mr. Howard?
Your Honor, I was just asking, cause I don't know how long I'm gonna be here. I'm just dealing with I think I go to court in like a week or so, and I was just, and once I get done with that, I know they're probably gonna send me back to prison. I was just trying to find out, is it any kind of way that I can, like, just, run everything like together somehow? So to where
That's what I was asking the court to
Huh?
do, Mr. Howard. Yes, that's what I was asking the judge to do.
Yes, ma'am, because I don't know if I'm gonna be here like another 90. I don't know. I mean, I might be here like another 3-4 weeks. You know what I'm saying? I just don't want to, like, once I'm finished with prison, have to come back to jail.
No, it's my understanding that your time will start as soon as the plea is taken, Mr. Howard.
So if I'm in prison, like, would the prison time count towards the 90 days too, or not?
What are you saying, Miss?
He wants to know if his prison time that he's going to spend going forward will count towards the 90 days.
And that I don't know, Ms. McLeod. I don't know how the prison, I don't know how the prison system works in that regard. But
we just want to know if we would consider the time to be running while he's sitting in prison, because he doesn't want to have to.
I'm happy for the time to be running, but I don't want to tell you something that is not going to be inaccurate. As far as I'm concerned, if he is in custody, then the time will be running on this charge.
Right, Your Honor, but I was just thinking this would be a Fulton County call as opposed to the person's call. We can decide today with counsel that it is going to count. And I just wanted to make sure.
And Your Honor, just as you've stated, we don't have control over when the time actually runs. We see what he's booked in on, and that's where the time is assessed.
Okay, my question is, and I think this is what my client wants to know, if he takes the plea today, will his time start running from today?
And I think that what we've said, Ms. McLeod, is that I don't know. I would imagine that it would. Ms. Sari is saying that she doesn't know. So if you want to have some time for to research that issue, since he's going to have additional time anyway, I'm happy to put this on next week's calendar so you can do some research as far as that goes. But I don't know. It would be my thought that it would, since he's in custody. But I don't want to tell you something and not really know the answer to it. And he has to do additional time at some point in the future.
Right, and that's what we're trying to avoid, Your Honor. So
right,
I guess
exactly.
I should, let me hear from my client. What do you want to say?
Your Honor, is there any kind of way I could do like any kind of like programs like to substitute for the 90 days or community service or anything I can that you all can offer me instead of doing like the extra time? I can just do like community service or any kind of programs or
Your Honor, if we could if I could pre-try with Attorney McLeod and we can come back to this position.
Okay, all right.
Thank you.
I'm happy to let you do that. Thank you, Ms. Sari.
Thank you, Your Honor.
All right. So let's we'll be back with you, Mr. Howard. We'll see what we can work out for you. All right. Who do we have next?
Position 38, Veal, going back to his case.
Okay.
And Judge, it's a non-negotiated plea. The real big point is just whether or not it'll be a stay away from all MARTA or just the incident location. But Mr. Veal accepts all the other conditions.
Does he have a history of criminal trespasses at MARTA?
I would ask pretrial to check if he has that history with MARTA. I don't see that.
You know what I normally do in these type of cases, Ms. Helen, regardless, is that if he has an active MARTA stay away, then I'll have him abide by any active MARTA stay aways.
Understood, Judge.
Does that suit everybody?
It suits me, Judge, and I believe it suits Mr. Veal, who uses the MARTA transportation.
Does it suit you, Mr. Taylor?
Yes, Your Honor.
Okay, so that's what we'll do. So now it becomes negotiated, is that right?
That's correct.
Very good. So Mr. Veal, is this Mr. Veal in courtroom 2?
Yes, sir.
Okay, Mr. Veal, you're still under oath, okay? Mr. Taylor?
Yes, Your Honor, the state's recommendation in this case is 12 months probation, serve 60 days, credit for 17 days already served, no contact with the victim, Erica Harmon, Harmon, and he's to abide by any MARTA stayaways.
Okay.
And yes, Judge, that is our understanding of the plea. I just went over with Mr. Veal that that'll be 13 additional jail days, but he understands that he would need to call MARTA to see if there's an active suspension, and if there is, he stays away until that suspension is done.
Okay. Mr. Veal, it's my understanding that in case 22 CR 007142B, you wish to plead guilty to simple battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
I understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Veal. Good luck to you, sir.
Thank you, sir.
Thank you, Judge.
Thank you, Ms. Helen.
Thank you, Mr. Veal.
Position 8, add-on, Mr. Shelton.
Yes.
And that's on the add-on, Judge, and so.
Okay, I'm sorry, hold on. Too many people are talking to me at one time. Ms. Lewis is talking to me in the courtroom. She has a question about Mr. Veal's case. And it's my understanding that the balance was what's happening with the probation once the jail time is done.
What he's on probation for, is it ground suspended? What he's on probation for, he's taking class, he's doing something, what is he on probation for?
Your Honor, it was my intention for the balance to be probated.
The balance is going to be probated, but there's not any additional terms of the probation.
Other than to just stay away from the victim. No.
We could do balance suspended, Your Honor, with the stay away.
Okay, all right, that's what we normally do. So thank you. I appreciate that, Mr. Walker.
That's not an issue.
All right, I'm sorry, courtroom 2, tell me where we are again.
This is the add-on, position 8, Shelton.
Okay, thank you.
You're welcome.
And
And
it's going to be an arraignment and bond hearing.
That's correct, Judge.
the state is prepared for the arraignment as far as the bond hearing. I don't want to get jump the gun, but he's being held on an FTA that was set by Judge Roth. He missed a PNA on 8/10 of this year. He initially had a signature bond, and he has $1,000 signature bond on each count due to the bench warrant or due to the bench warrant. So I would ask that as far as the bond hearing, it's sent back to Judge Roth, but if he wants to be arraigned today, I do think that's appropriate.
Okay, and that's my normal practice, Ms. Helen.
And we'll arraign it, Judge.
Okay, Mr. Shelton Tipton, good morning. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Walker, what is the offer in this?
After reviewing it, this was a DA transfer and actually involved a handgun, so the offer will be 12 months to serve.
Okay. Mr. Shelton Tipton, you've been charged in case 22 CR 003114A with public drunk and possession and use of drug-related objects. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Shelton Tipton? Guilty or not guilty?
Excuse me, sir, I'm confused a little bit. Said 12 months to serve, 12 months to serve was requested from the DA for my father.
Judge, let me give a opportunity to speak to Mr. McKell. If we could go to another position, I can call courtroom 2 really quickly here.
Okay, and let me just make sure that I have clarification also. That might help Mr. Shelton Tipton also. So he's charged with public drunk and possession and use of drug-related objects. Where does the gun come in, Mr. Walker?
He had possession of a firearm and he was charged with possession of a firearm by a convicted felon. He went to felony first appearance. They transferred it to us. They dismissed the charge, but however, because he did have a loaded handgun, I don't know if you want to go to the facts of the case, because he did have a loaded handgun and was walking around in his underwear and being belligerent in public. That is the basis for the state's recommendation.
Okay, but he's not being charged with a gun charge.
I understand that. And like I said, it did start off as a felony and they send it to our office and that's our recommendation. If he wants to do a non-negotiated plea, that's fine, but that is the basis for our recommendation.
Okay, well.
He is on felony
Ms. Helen-
probation is my understanding.
All right, Ms. Helen, all I see is a public drunk and a possession and use of drug-related objects. So if you want to advise him on a non-negotiated plea, that's up to you. If you want to have time to talk with him, I'm happy to give you that opportunity. But I only see 2 charges here that in that regard.
Understood, Judge. I'll give him a call.
Okay, who can we go to next?
Position 22 Ridley.
Say it again.
Position 22 Ridley.
Okay, thank you.
Oh, you know what? That's Helen's case. I just realized that.
Okay, we have one of Mr. McLean's cases.
Position 7 Davis. That's it. Add-on.
And Your Honor, we are also ready for my client
7
at the
Davis.
court's discretion.
Okay, so position 7.
Negotiated plea, yes.
Mr. Davis. Good morning, Mr. Davis. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Thank you, sir. Ms. Sori?
Yes, Your Honor. The state's offer in this case is 12 months to serve, 28 days, credit for time served 14 days, the balance probated, an anti-theft course, and to stay away from the Macy's located at 5000 North Point Circle in Alpharetta. Nothing further.
Mr. McLean?
Your Honor, Mr. Davis does ask the court to accept his negotiated plea.
Mr. Davis, it's my understanding that in case 22 CR 0073328, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, no, sir.
All right, I'll accept the plea as negotiated. Mr. Davis, I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Sure.
All right.
Thank you, Your Honor.
Good luck to you, sir.
All right, good. Thank you.
Position 19 Pickett.
Ms. McLeod. What are we
Mr.
doing?
Howard.
What are we doing with Mr. Pickett today? Is this the case, Ms. McLeod?
Yes, Your Honor.
And what are we doing with Mr. Pickett today?
I didn't see an offer for him, Your Honor, so I imagine it's going to be arraigned.
Okay, do you need time to? Ms. Story, I have an offer here. Ms. Story, you want to put the offer on the record?
Yes, Your Honor, and I'm sorry, which position was that?
Position 19, Mr. Pickett.
Okay, the state's offer in this case is 12 months to serve 60 days, credit for time served 16 days, the balance probated, an anti-theft course, as well as an ADET, and to stay away from the incident location and no contact with the victim.
Okay, and this is, do you need time, Ms. McLeod, to discuss that with Mr.
I do,
Pickett?
Your Honor.
Okay, so can we get Mr. Pickett to a phone, and Ms. McLeod will give him a call. Do we have any of Mr. McLean's cases?
Position 15, McReynolds.
Okay, thank you. This is a negotiated plea, Mr. McLean?
Correct.
All right.
Your Honor, I'm sorry to interrupt. Based on this case, this is a dual arrest. So the state is still doing some investigation with this. We would consent to a signature bond in this case while we continue to investigate.
Much appreciated.
Okay, so let me see what the bond is currently. Position 15.
Yeah, he fell to a plea before Judge Rader on November 16, 2021. This was originally a binder case. So, the original law from the binder from magistrate court was a $5,000 SOB pre-trial. But I think pre-trial should be.
Okay, is there a, sorry, do you know if there's a stay away and a no further contact?
That's what we would be requesting, Your Honor.
Okay, so if you a signature bond, let's do a $2,500 signature bond through the jail on each count, which will make it a total of a $7,500 SOB through the jail. Who do you want him to stay away from?
Her name is Katie, Katie, and last name is Aycock.
Katie Aycock, and no further contact with Ms. Aycock, and stay away from where?
830 Crew Street, Southwest in Atlanta.
Spell, is it Crew or Crew?
Crew, CREW.
Crew Street. Did you get that, Mr. McLean?
I did, Your Honor, and since that was going to be part of the plea about Ms. Aycock and no contact, that's still, I don't have to ask him that. He's already agreed to that.
All right, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr.
Thank you.
Reynolds.
How much is on each charge?
$2,500.
On each charge?
Yes, through the jail.
May I take just a second, Your Honor? Mr. McReynolds, can you hear me?
Hold on, come, we have to go back.
Yeah, sure.
Okay, just call my office tomorrow, please, and ask for Mr. McLean. Call the main number of the public defender of Fulton County and just ask for me, okay?
You need the number with it?
It's 612-5200. So 404-612-5200. I just want to make sure you don't miss any court dates in the future, and we'll talk about that. Thank you.
McClain. Yeah,
Thank you.
Thanks.
Got position 39 here, Judge.
And
Okay,
Judge, I apologize, didn't want to interrupt you. We're actually ready for position for the add-on 8, and I believe the additional position is mine too.
Along with position. Ms.
Okay.
Butler?
all right, so you all just tell me where we're going next. Who is up?
Position 39, Judge.
39, okay, thank you.
And that's an arraignment, Your Honor.
Okay. Good morning, Mr. Walker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Walker. You've been charged in case 22 CR 007417C with simple battery, family violence, and cruelty to children in the 3rd degree. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Walker? Guilty or not guilty?
Yes.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see. Do we not have his bond?
This is ongoing case.
While I'm getting his bond, let's see. Ms. Roberts?
Yes, can you hear me?
Yes, do we have his history?
Yes, he has 31 cycles. He currently has a few open cases out of Fulton County. The first is for battery and theft by taking, 22 CP 206276. The second is for simple battery and cruelty, 22 CP 206305. The third, he appears to be on probation for possession of marijuana less than an ounce and battery, 21 CR 004-007E. 12 months probation. Disposition was June 1st, 2022. He has a battery conviction from 2007, a battery conviction from 2008, and a purchase, possession, or have a controlled substance conviction in 2005. And nothing.
I apologize.
Okay, thank you, Ms. Roberts.
His original bond was through, he made it through a surety bond of $500 on each charge.
Yeah, Judge, I have that he's bonded.
$500 on the pool D and about $1,500 on the surety. For the simple battery. So that was $1,500 and $5,000. He made it through, so he made it through a second chance bonding company. He's not being held in jail for these charges.
Yes, Judge, that's why I asked for an arraignment. This case is holding him. There's another case that's holding Mr. Walker.
Okay, I'm sorry, I thought you asked for a bond hearing.
It's just an arraignment, Judge.
Okay, all right, good luck to you, Mr. Walker. Who do we have next?
This is the add-on position 8, Shelton.
Have you had an opportunity to speak with Mr. Shelton Tipton?
I have, Judge, and we're prepared to move forward with that bond hearing, Judge.
Okay, and let's see. Has he already been arraigned on this?
I'm not sure, Judge.
Okay, let's get him arraigned first. And is there a bond in there?
He's being held on $1,000. Again, this started out as a signature bond. He FTA'd. He's being held on $1,000 surety bond on each count. But
Okay,
we'll do the arraignment first, and then we can go into the hearing.
okay, thank you. Mr. Shelton Tipton, I'm not sure if I've already sworn you in, but let me just redo that. Yes, sir. Your client has his hand up, Miss Helen.
Yes, Mr. Shelton, what can I do for you?
Hey, I apologize. I wanted to let you know I did have a signature bond. I actually missed my signature bond
But
for,
that's okay, Mr. Shelton, but we're gonna move forward with the bond hearing, okay? I've got some good information to tell the judge, okay?
Okay.
We got it.
Okay,
Because it's supposed to be set for a plea.
okay. Mr. Shelton Tipton, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes, sir.
Okay, thank you, sir. You can put your hand down. You have been charged in case 22 CR 0031114A with public drunk and possession and use of drug-related objects. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, sir? Guilty or not guilty?
Not guilty, sir.
All right, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Okay, so who'd like to speak on bond?
Well, I would like the pre-trial to read the history. Excuse me, pre-trial to read the history first, please.
Okay,
Give me one moment, it's loading. I can tell you now that he does have 2 cycles out of Iowa. The last cycle being from 2011, and that was a conviction for a habitual violator. And then a 2011, now I can't say, okay. A theft conviction out of Iowa, also from 2011 misdemeanor. Out of Georgia, he has a total of 32 cycles. He had a conviction from, it was a first offender that was revoked in 2014. And that was for willful obstruction, simple battery, family violence, 2 counts, terroristic threats, interference with government property. That was out of Clayton County. He had a 2013 criminal trespass conviction out of DeKalb County. A probation violation from 2013. A criminal trespass conviction from 2013, also out of DeKalb County. A willful obstruction conviction 2013 DeKalb County. 1 FTA 2013 DeKalb County. A DUI conviction 2014 DeKalb County. Battery family violence conviction from 2016 out of DeKalb County, along with the disorderly conduct. 1 FTA from 2016 out of DeKalb County. Another FTA from 2016. I'm going to waive, sound as a CWAC misdemeanor conviction from 2018 out of Fulton County. probation violation from 2018, probation violation from 2019. I'm sorry, there's so many pages it's loaded. Another probation violation from 2022. FTA from October of 2022. And nothing further to add.
Okay. Mr. Walker?
Okay, yes, Your Honor, and to perfect the record on that felony case 17 SC 153072, it was a felony conviction in 2018. He was convicted of 6 counts of felony obstruction, simple battery against a police officer, criminal trespass, and a count of sexual battery. He's still under sentence for that offense, and that is relevant because in this case, on May 17th of 2022, APD was called to the gas station at that location about a male walking around the parking lot with a handgun in his underwear. Upon arrival, they made contact with the defendant. They asked him to drop his weapon. He refused. He was being belligerent. He had an open can of Colt 45, according to the witnesses on the scene. He had consumed that alcoholic beverage before the police arrived. He was not being compliant with officers after commanding him several times to get to the ground. He was yelling out about his religion and his rights. The officers actually had to draw their firearms to get the defendant to comply. At that time, he was apprehended. A loaded 9mm high point C9 firearm was confiscated from his person. At that time, he was arrested for firearm of a convicted felon, public drunk, and possession of drug-related objects. As I stated, this was the first appearance, and they sent it to our office, and we are now left with those 2 charges. But based on his history, like I said, he's on probation for 6 counts of felony obstruction. He is a convicted felon, and due to the fact that he was drunk in the public with a loaded 9mm high point, the state has grave concern for the safety, and we take gun cases very serious, as we currently have a gun epidemic, specifically here in Fulton County. So that is the basis for the state's 12 months recommendation. I understand that the DA's office did transfer the case to our office, but that does not change the facts of this case. It does not change the fact that he is a convicted felon. It does not change the fact that he was drunk in public with a firearm that was loaded in his underwear in broad daylight, and put the safety of Fulton County citizens at risk. And the officers actually had to draw their firearms to get the defendant to comply with their orders. So we're asking that the bond remain as set is more than reasonable. And as you've heard, he's had several violations of felony probation. He has over 32 cycles in Georgia. He has several FTAs. He FTA'd on this matter on 8/10 of 2022 in front of Judge Roth. He was initially granted a signature bond. And it's the state's position that a $2,000 surety bond is more than generous, and we ask that remain as set, Your Honor.
So is that 1 per charge, 1,000 per charge,
That
Mr.
is
Walker?
correct, Your Honor. 2,000 surety in total. And based on everything that I just stated, his history of FTAs, violations of probation, and the facts, we're asking that it remains as said.
Thank you, Ms. Helen.
Hey, Judge, this is a bond hearing this morning for Mr. Shelton Tipton. I just want to clarify, Odyssey shows that a firearm or possession of firearm by a convicted felon was dismissed. I hear all the allegations. That charge is not here. The charge that we do have is public drunkenness and possession and use of drug-related objects. I hear his history. Mr. McKell and I are very aware of his probation cases. Today, Judge, we are asking for a signature bond in the same amount. Again, we are reiterating that possession allegation was dismissed altogether. Mr. Shelton Tipton is 30 years old. He's a lifetime resident of Georgia, specifically Fulton County. He has a 7-year-old son who lives in Vidalia with his mother. And Judge, he's a primary caregiver of a 7-year-old son, Judge. For the FTAs or failing to appear, Judge, Mr. Shelton Tipton was not aware he needs to go in person. He cannot call to update his address to the clerk's office. I have an updated address, which I'm going to provide to probation. I believe that's going to alleviate any more failure to appears. I have a permanent number. And again, he has strong family ties here in Georgia. This is not a long-standing violent offender, Judge. He's not going to leave the state. I don't believe he's going to miss any more court dates. His mom is in Ellenwood, has been there for 14 days. He is from Flint, Michigan, but he's been in Georgia for the last 12 years. Judge, he has a long-standing history with philanthropy. Let me get into that part. He has a media production company, specifically music production, a nonprofit organization that he actually brings kids from the community to learn music theory, to be out of the streets of Fulton County. So Judge, I hear the allegations of his history, but this is a person who is inside of the community. This is a father inside of the community. Judge, I am asking for that signature bond in the same amount. Again, I do hear the allegations, but let's go to the Ayala factors. I don't believe he's going to miss another court date. I have an updated address. I hear the FTAs. I hear the probation violations. I think that that was due to the address not being updated in person. And quite frankly, Mr. Shelton Tipton didn't know that that was the process. So Judge, we are asking for that signature bond, that bond modification. I don't believe he's a danger to the community. Again, the charges we have here are public drunkenness, possession and use of drug-related objects, Judge. So we are asking for that signature bond in the same amount.
And if I could just briefly respond, as the court is well aware, this defendant has 34 cycles spanning through 2 states. He's no stranger to the criminal justice system. He's on felony probation. He's well aware of what this process looks like and what is required and what the law requires him to do. Whether the charge by the DA's office was dismissed or not, it does not change the facts of this case. He was drunk in public in his underwear with a loaded firearm. So the state could, contends that he does pose a risk to the safety of the Fulton County citizens. He already had signature bonds on this matter, and then to allow him to miss court and then turn around and give another signature bond in light of his history would be wholly inappropriate. We ask that the court do what it normally does in this situation, send it back to the division judge who set the bond on the bench warrants. And with that, nothing further from the state.
Yeah, because of his history, Ms. Helen, I agree with Mr. Walker. It'd be different if he had a clean history and these were the only 2 charges and he hadn't missed court before. I'm going to leave the bond where it is at the present time, 1,000 good per charge.
Understood, Judge.
Okay, good luck to you, Mr. Shelton Tipton.
Position 9 and 10, South.
And these are going to be negotiated, please. Is that right?
9 and 10, Mr. Harden, are negotiated, please.
Okay. Good morning, Mr. Harden. I'm Judge Eric Moore. Good morning, sir. I'm Judge Eric Moore. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay. Can you raise your right hand for me, Mr. Harden? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. I'm sorry.
Yes, Your Honor. For the first case, position 9, the state's offer is 12 months to serve 44 days. Credit for time served 22 days. The balance probated. An FFIB course. No contact with the victim, whose name is Vivian Harden, and to stay away from the incident location, 1994 Bent Creek Way in Atlanta. And for position 10, the same terms in jail time apply. However, the victims in this case would be Wildretta Black, third-party transfer of any minor children, and nothing further, Judge.
Okay. Mr. McLean?
Your Honor, he asked the court to accept his negotiated plea. We have the paperwork ready to send to the court.
And Your Honor, that's to run concurrent.
Okay, Mr. Harden, it's my understanding that in case 19 CR 009714F, you wish to plead guilty to public drunk and criminal trespass and damage to property. And in case 22 CR 007051F, you wish to plead guilty to 3 counts of cruelty to children in the 3rd degree, battery, family violence, and theft by taking. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Harden. Let's see, I'm going to waive the probation fees for you while you're on probation, but you're going to have to be on probation for the entire time, okay?
Okay.
All right, good luck to you, Mr. Harden.
That mean I go home?
Say it again.
That mean I go home?
If you don't have anything else holding you, Mr. Harden, you will be released when the jail can process you out, okay?
Thank you, sir.
Hey,
You're welcome.
Judge Myra, what address do you want her to report to when he has to report to probation?
Can we put the probation's address in the chat?
Probation is on there.
Pro-
JCS Ms. Thomas. Send it to her.
Ms. Thomas? We'll have to get him where he needs to report. Mr. McLean, can you get him later after court where Mr. Harden needs to report to probation? I don't think probation is with us.
She's on there.
She's, I know, but she's, therefore she's not with us. Okay, we'll, Mr. McLean, we'll get that to him so that he knows where he needs to report, please.
Okay, thank you.
Very good.
Who do we have next?
Position 40.
Okay. We need a breakout room.
Yes, please, Your Honor.
All right. Who all needs to go into the breakout room?
It'd be me, Mr. Walker, most likely, PD Helen, and pretrial.
Okay.
I'm sorry, Your Honor, what case is it, what position is this?
Position 40.
And what is, I don't believe we need a breakout room, so.
Okay, I was requesting a bond hearing for position 40, Judge. I didn't know if you wanted to break out room to waive the sounding of the charge or.
The state is objecting of waiving any sound of the charges again.
Okay, well, you all were the ones who requested the breakout.
Okay, so we're rescinding the request.
Okay.
You're not going into a breakout room. Sorry for any confusion.
Okay.
And,
All right. Mr. Wallace, good morning.
How you doing, sir?
I'm doing well. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sure.
Okay, you can put your hands down. Thank you, Mr. Wallace. You've been charged in case 22 CR 007085H with one misdemeanor offense. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to this charge, Mr. Wallace? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date. Do we have his bond?
There's no bond sent on this. There's a bond over.
Okay, may I get his,
If that's felony court, then, you know, got released. And now it's with us and it was never a bond set to start.
okay, Ms. Roberts, may I have the history, please?
I'm showing one cycle out of Georgia, which is this current arrest. I'm showing one cycle out of South Carolina from 2014 for armed robbery, and that was a felony conviction. And
What year is that?
2014 out of South Carolina.
Okay,
And then I'm showing 12 cycles out of Pennsylvania, with the last being in 2014 for escape. There's no disposition listed. I am showing a terroristic threats. A criminal trespass conviction and a burglary conviction out of Pennsylvania from 2006. A 2003 conviction out of Pennsylvania for violation of a controlled substance and cosmetic act. And nothing further to add.
okay, Mr. Taylor?
Yes, Your Honor. The facts of this case are that the victim and her partner, Miss Floyd, went to the defendant's house to watch a movie. When they entered the house, the defendant immediately began making remarks about the victim's buttocks. The defendant offered a room to the two women to sleep in, and they took them up on the offer. Miss Floyd stated that, I'm sorry, Your Honor, the defendant stated that he was going to work. However, during the middle of the night, the victim's friend awoke to find the defendant removing his penis from the victim's buttocks. The victim, however, remained asleep until the victim's friend, Miss Floyd, awoke her to tell her what happened. This was just transferred down from the DA's office on October 18th, 2022, from an aggravated sodomy charge. In this case, Your Honor, I don't believe that there was a bond set by the DA's office. However, in light of the charges and his history, the state would be asking for a $5,000 cash bond.
Do you have the alleged victims' names to go on the bond? If you want, do you want to stay, no further contact, Mr. Taylor?
Yes, Your Honor.
Okay.
The victim's name is.
Put the victim's name in the chat.
Sure.
If he does, make sure it's going directly to individual, not everybody.
Okay, Ms. Lewis, please. Is there a stay away? Or is it his apartment?
I'm sorry, what was that, Your Honor?
Are you requesting a stay away?
Yes, Your Honor.
Okay,
It would be to stay away from the victim. I believe this took place at his house, so there wouldn't be.
all right, so, no,
Stay
all
away
right.
at the location.
Ms. Helen?
Yes, Judge. When I went down and spoke to Mr. Wallace, he's been confined and incarcerated for the last 170 days. Went through the process. No witnesses appeared in his previous case. And from what he believes is that then the charge was dropped down to what it is currently, the misdemeanor it is currently. And that happened in October, Judge, for failing to find any witness to prosecute this case. And now we're here, Judge, we're asking for a signature bond. In this case, I'm going to give you a couple reasons why. Based off of the Ayala factors, he does not have the history to state that he's a long-standing violent offender with these particular charges. His history may be, I wouldn't even say long, but it doesn't even repeat these specific charges. He's not a violent offender with these particular charges. Judge is 46 years old. He does have a history in Philly as far as being from Philly, Judge, but he's been in Georgia for the last 20+ years in Fulton County. He also has strong family ties here in Georgia. His sister who lives in Fulton County, he does have a high school education. He did complete a Job Corps program, Judge, and he is employable. He's been a barber or has his own barber shop and offering barber services for the last 34 years, Judge. What we're asking for, Judge, is that this be set as a signature bond. Based on the Ayala factors, he doesn't show that he's actually going to miss any court dates, reoffend with this particular charge. He doesn't have the history with this particular charge. And for the alleged accusers, he had no contact for 170 days with any of those people mentioned. He does not want any contact, and he will go forward with the no contact, Judge. With this particular case, I am asking for a signature bond for Mr. Wallace. Again, he's almost sat the full maximum time for a misdemeanor for this case, Judge. So we are asking for a signature bond. If you feel that he is ineligible for that signature bond, we are asking for a $1,000 surety bond, Judge.
All right, it's going to be a $5,000 good bond, no further contact with the alleged victims, and no drugs, alcohol, or weapons while out on bond.
And can I have an opportunity to speak to jail court's iPhone if I can message them my number in the chat? Is that okay?
No, it's fine with me, Ms. Helen.
Thank you, Judge.
Next, we have position number 23, Your Honor, Mr. Roby.
And that's my position, Judge. I'm still just trying to speak to Mr. Wallace, if we can go to another position.
Do we have any of Mr. McLean's cases or Ms. McLeod?
Yes, Your Honor, at the side annex, Ms. Fagan, position number 8.
Your Honor, that's going to be a request from me to go to the competency calendar.
Okay, position 8, we'll put on a competency calendar.
I'll get with Ms. Helen about any necessary paperwork and forms.
It'll be December 1st.
It'll be December 1st. Mr. McLean.
Thank you.
Who else do we have?
And Your Honor, I'm going to have the same announcement as to needing to go to the competency calendar on position 12 and position 5.
All right, position 12. And position 5.
Correct.
Okay, we've already got, all right. Who do we have next?
Your Honor, can we go back to position 1 and 2, Mr. Bodie?
I'll talk to Mr. Bodie by phone. I've explained to him on position 2, the state has not made an offer, and I'll explain to him further what that means.
Okay, you'll do that at a later time, Mr. McLean?
Yes, Your Honor, I can visit him tomorrow in the jail.
Okay.
All of the cases I have here are for Helen.
All right.
Actually, no, I have Mr. Pickett. Position 19, Grant Pickett.
Okay. And this is
my case, Your Honor.
What are we doing with Mr. Pickett?
Mr. Pickett will be taking a plea, Your Honor.
Okay. Good morning, Mr. Pickett. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Yes, Your Honor.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Sorry.
Yes, Your Honor. The state's offer in this case is 12 months to serve 60 days, credit for time served 16 days, the balance probated, an anti-theft course, ADET, stay away from the incident location, which is Starbucks in 1 second. That's located at 506 Moreland Avenue in Atlanta, and no contact with the victim, whose name is Willie Harrison. Nothing further.
Ms. McLeod?
Your Honor, that is our understanding of the terms of the plea offer, Your Honor.
All right, Mr. Pickett, it's my understanding that you wish to plead guilty in case 22 CR 007149D to theft by taking. Is that correct? You need the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with her representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? I'm sorry, I didn't hear you, Mr. Pickett.
Yes, yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Mr. Pickett, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation will terminate, okay?
Yes, sir. Thank you, Your Honor.
All right, so the sooner you get through with this, the sooner you'll be on probation. Good luck to you, sir.
Thank you, sir.
Position 12, Jacobs.
It's my understanding that position 12 is going to the competency calendar. Is that incorrect?
That's correct, Your Honor.
Okay, so we don't need Mr. Jacobs. Thank you. So South Annex, do we have any?
Yes, Your Honor, we have position 3, Ms. Butler.
Hold on, Ms. Milton, hold on 1 second. We wasn't done, Judge. I'm sorry. We wasn't done.
Oh yeah, Miss Helen, I thought the rest of your cases were Miss Helen's cases.
Oh, for Ms. Helen, okay. I
Right.
apologize. I just walked back.
Okay.
into the courtroom.
You're fine, you're fine.
Judge, I'm ready.
Sorry, Ms. Milton.
Okay, so I didn't know Miss Helen was back with us. So you don't tell me where you want to go now that Miss Helen's back. You
I
want to
just
go?
want to, yeah, if we can do
Okay.
position 23, Mr. Roby.
Okay,
Ready, Judge. The only reason it's non-negotiated, he agrees to all of the other conditions. It's probation for 2 years. We're asking it for it to be concurrent for 1 year, Judge.
what's his history?
He has 31 cycles. He has a 2010 felony conviction for willful obstruction of a law enforcement officer. He has a 2013 simple battery family violence conviction, along with a theft by receiving stolen property misdemeanor. He has a probation violation from 2013, FTA from 2013, probation violation from 2014, an FTA from 2015, has a terrorist threats conviction also from 2013, a burglary conviction from 2017 out of Fulton County. He appears to be on probation for that case. It was a 19-year probation sentence, 16 SC 146272. A disorderly conduct conviction from 2017. That case was amended from a possession of marijuana less than an ounce. Probation violation from 2021. I do see the probation violations for criminal attempt to commit entering auto 12 SC 114536. I'm not sure if that's still an active probation or not. And then another FTA from October of this year. And nothing further.
Thank you. Good morning, Mr. Roby. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Taylor?
Yes, Your Honor. The facts of this case are that officers received a BOLO in reference to several theft of motor vehicles throughout the city. They spotted a Nissan Murano driven by the defendant, matching the BOLO. They attempted to stop the vehicle, but he sped away at a high rate of speed. They put out a helicopter to search for the defendant, and about 40 minutes later, they located him at a Ruby Tuesdays. He was jumping out of the car and running for the wood line. Officers were finally able to detain the defendant. He does have 5 active suspensions from 2016 to 2021 on his driver's history for failure to appear. And I'm showing that he has 2 open cases, one for possession of firearm by a convicted felon, firearm during commission of certain felonies from 2021, and a felony possession case from 2021. Because of that, I believe that the 2 years of probation is appropriate. Just to put the plea recommendation on the record, it would be to plead to count 1, fleeing and attempting to elude an officer, 12 months probation, 30 days to serve, credit for time served with the balance probated, $1,000 fine, 40 hours community service, and he is to plead to count 5, obstruction of a law enforcement officer with the $300 fine, 12 months probation consecutive, and upon completion of the terms and payment, the final 12 months can be suspended. He needs to have no traffic violations while on probation. The counts 2, 3, 4, and 6 would be null frost.
This goes back to 2018. Mr. Taylor, why is this taking so long to get here? Did he get away from them?
I don't believe so. I'm not sure why it took so long from the incident date. Let's try to see if I can figure it
Judge, I
out.
do have the failure to appear. I believe that's why that case is here.
He failed to appear twice in front of Judge Richardson on February 9th of 2021 and April 26th of 2022.
Okay, all right.
He was accused back on December 9th of 2019.
Okay, thank you. Ms. Helen?
Yes, Judge. Mr. Roby agrees to all the other conditions. We're only asked for the 1 year probation, and essentially that it runs concurrent with the other probation, Judge.
Okay. Mr. Roby, it's my understanding that in case 19 CR 009778F, you wish to plead guilty to fleeing or attempting to elude a police officer and obstruction of law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated. Mr. Roby, except I'm going to have them run concurrent instead of consecutive. So you're going to be on probation for the entire 12 months. I'm going to waive the fees while you're on probation, but I'm going to require that you be on probation for the entire 12 months, okay?
Okay, can I ask you one question, sir?
Yes, sir.
I know I got some driver license failure to appeal. I'm trying to get my license, but they were currently stopping me. How do I handle them?
Mr. Roby, I'll give you a call. All of that's through the DMV to try to get your license back. But this right here says, I'll give you a call, okay?
Okay.
All right, good luck to you, Mr. Roby.
Okay.
Thank you, Judge.
You're welcome. Who do we have next?
Position 11.
Okay, so what are we doing with Mr. Howard?
Your Honor, after speaking with defense counsel, we are going to give a time served offer in this one.
So 12 months to serve, is that,
It'll actually be 13 days. Credit for time served, 13 days.
Okay.
With the same conditions stated.
okay, balance probated, family violence intervention program. No further contact with Ms. Carter and stay away from the McClellan Avenue address, no drugs, alcohol, weapons.
That's correct, Judge.
Okay. Anything further, Ms. McLeod?
No, Your Honor.
Okay. Mr. Howard, let me just make sure that I've already sworn you in. If I have, let me just do it again so that we can have it on the record. Can you raise your right hand for me? Do you swear from the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Is that a yes? I'm sorry.
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Howard, you've been charged in case 20 CR 005059H with battery, family violence, and simple battery, family violence. It's my understanding that you wish to plead guilty to these charges. Is that correct?
Yes, sir.
Were you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
I can't hear you, sir.
Has anybody forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Howard. I'm also going to waive the probation fees for you while you're on probation once you get out, so that you can get to help you get and stay on your feet, okay?
Okay, thank you, Your Honor.
All right.
Thank you, Your Honor.
Have a good day, Mr.
Can I get a
Howard.
clarification of that, please, again?
12 months to serve, 13 days credit for time served, 13 days balance probated, family violence intervention program, no further contact with Jada Carter, stay away from the McClellan Avenue address, and no drugs, alcohol, or weapons while out on bond.
And he's still being on probation the entire time.
Yes, waive fees. Okay, thank you, sir. Who do we have next?
Position 22, Ridley.
It's an arraignment and a bond hearing.
That's correct, Judge.
Good morning, Mr. Ridley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down, Mr. Ridley. You've been charged in case 22 CR 007349Y with simple battery, family violence. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation?
I do, Judge.
How do you plead, Mr. Ridley? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Mr. Ridley was given a $3,000 good bond on October 26th by Judge Mincy. Is there a history?
Yes, 2 cycles out of Georgia and 4 cycles out of Alabama. The last arrest out of Georgia was from 2019 for possession of meth and purchase, possession, manufacture, distribution, or sale of marijuana out of Gwinnett County. The disposition says conditional discharge program pending. So I'm not sure of the outcome of that case. And then out of Alabama, he had a 2003 possession of marijuana and weapons. And nothing further to add.
Sorry.
Yes, Your Honor. In this case, during an argument with the victim, whose name is Tara Winkfield, that's WINKFIELD, the defendant struck the victim in the arm with a stick. Our office was able to speak with the victim. She stated that she and the defendant were in a relationship. They're no longer together because of this incident. And this was not the first time he has been violent with her, and she has called the police before, but this is the first time he has been arrested. She wants no contact with him and to stay away from the incident location. And Your Honor, we are requesting that that bond remain as set for those reasons. Nothing further.
Ms. Helen?
Yes, Judge. This is a bond hearing for Mr. Starling Ridley. Specifically, we're asking for a signature bond, and I'm going to get into the reasons why. His history, that conditional discharge, I believe if they complete that, it's almost like covering that charge, Judge. I think he's still in that conditional discharge program. So I do hear the history, but he doesn't have a history of a violent offender towards any of his partners or any of his family members. So this simple battery family violence is completely out of the ordinary in his history, Judge. So we'll get into the case. If you read the warrant, it has one line said allegedly that Miss Wheatfield was hit by a stick. When I spoke to Mr. Ridley, the police have been called more than 40 times by Miss Wingfield, who uses the police to try to come and exert control and power over Mr. Ridley. This one time out of the 40 times that have been called, they believe to arrest Mr. Ridley, but she's called many, many times, and this was only the one founded. Specifically, when I talked to Mr. Ridley, he made no contact with her at all, Judge. So we are asking for that signature bond. He is 46 years old. He is a primary caregiver of his mother, a family member, Judge. He does have a college history in associate's degree in criminal justice, Judge, from Balder College. He also is a primary caregiver of a 7-year-old daughter. He has obviously a high school education from Lakeside High School. He is quite employable. He is a HVAC electrician, an appliance specialist between many other appliances, lawn services as well, Judge. And I just want to put in there, he was given a scholarship to go to UAB to play football. This is a very great person for a signature bond. I don't believe that he's a danger to the community. He wants no more contact with Miss Wingfield. From this behavior, constantly calling the police on false allegations, he wants no contact. So he agrees to the stay away from Miss Wingfield. Again, Judge, he doesn't have the history. There's no contact with Miss Wingfield. He doesn't want any. I don't believe there's a danger to the community. And I believe he's going to come to all of his court dates. I didn't hear a bunch of failure to appears in his history, Judge. Mr. Ridley takes this so serious. He wants to have this jury trial so that it can be shown that these are false allegations. We are asking for that signature bond in the same amount. I think it's a $3,000 bond.
And Your Honor, just briefly, I will state to the court that when the officers went out, they did not find probable cause to arrest the victim in this case. They arrested the defendant. So this is not a dual arrest situation that we have here. So we do have violence, and it is against our victim, and we are asking for that bond to remain as set.
And just one second, Judge, it is an allegation, and I do understand Your Honor does not like history of constantly repeating family violence charges. This is the one singular in his entire history. This is not who this person is, and it is definitely an allegation, and we are asking for that singular sig bond, Judge.
Where's the stay away from, Ms. Sorry?
Yes, Your Honor, it is 9994 Catherwood, that's Katherwood Drive in Atlanta.
Do you have a reason to go back there, Ms. Helen?
Mr. Ridley, do you have any things at that location? Do you have any reason to go back there?
Everything in the house is mine.
Okay, hold on, Mr. Ridley. We're asking also if there be a one-time escort granted with an officer to get any items that he believes are his from that location.
All right. So it's going to be, take it down, Ms. Helen. I'm gonna grant you relief, a $5,000 signature bond through pretrial per the judge. 1-day anger awareness. No further contact with Ms. Winkfield. Stay away from the Catherwood Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond.
Thank you, Judge.
Okay, let me just make sure that Mr. Ridley understands. Mr. Ridley, No contact means absolutely no contact. It means no phone contact, no personal contact, no email contact, no social media contact, no contact whatsoever. If there is any contact, you'll be in violation of this bond, and you'll be right back where you are. You understand me? All right. Good luck to you, Mr. Ridley.
Thank you, Judge.
Who do we
Thank
have-
you, Your Honor.
who do we have next?
Position number 3, Ms. Butler.
Okay. I'm sorry, the court's gonna need to take a 2-minute break. Give me 2 minutes.
Judge Morrow,
Yes.
I'm sorry, we're completed here in courtroom 2. I just want to make.
Oh, okay. All right. Well, good. Perfect timing. Thank you. I'll see you this afternoon.
Thank you.
Okay.
McLean, can you please check your chat? Thanks.
All right. Give me 2 minutes, please. Okay, I'm ready. Who do we have next?
Position number 3, Ms. Martha Butler.
Okay. What are we doing with Ms. Butler today?
She's going to be taking a plea today, Your Honor.
Okay, thank you. Good morning, Ms. Butler. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Ms. Butler? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, ma'am. Ms. Story?
Yes, Your Honor. I have 2 cases for this defendant. I'm not sure if Ms. McLeod is aware of the theft by taking charge.
Yes, I'm aware of both of them.
Okay, and she's accepting the plea for both?
Yes.
Okay, thank you. The state's offer for the cases are 12 months to serve 32 days, credit for time served 16 days, the balance suspended on position 3 and to stay away from 1600 West Taylor Avenue in East Point. And for the theft by shoplifting, case number 22 CR 007-278F, the same jail time with conditions of the balance being probated, an anti-theft course, and to stay away from Corner Market located at 3332 Colville Avenue in Hapeville.
Okay, Ms. McLeod.
Yes, Your Honor. We agree that those are the terms of the plea offer, Your Honor. We would ask the court if it's possible to make my client's probation non-reporting. And the reason for that is, Judge, she is 69 years old. She has various illnesses, doesn't get around very well. So it's going to be a real hardship for her, given the nature of her illnesses and the fact that she doesn't drive and doesn't get around well, to make it to probation.
Okay, I think that they can allow her to report by phone, and as soon as she does the anti-theft class, Ms. McLeod, I'm gonna have the probation terminate. So I think she's gonna have to sign up for probation, and then they can do it by phone. And once she does the anti-theft class, then she'll be done with it. Does that suit her?
It would, Your Honor.
Okay.
Excuse me, Your Honor.
Yes, Ms. Thomas.
We have online now, so that would be online or remote. If she has an
Okay.
address and doesn't have a phone, we can get the address and send it through mail. But if she has a phone, it has to be a good phone that she can get text messages from, because they
Okay.
can do online reporting.
All right, so Ms. McLeod, if you can, your client has her hand up.
Yes, Ms. Butler, do you have a phone?
South Annex, you're
I
muted.
think
South
she's
Annex.
muted.
Sorry. I have a phone, but I don't do online. I don't have a computer.
Okay. but
And your phone is able to accept text messages?
Yes, ma'am.
Okay.
All right, so we can get it done that way. Okay, anything further?
Yes, Your Honor, I'm sorry. The charges are to run concurrent.
Okay.
Yes, Your Honor.
Turned it off. Girl, the darn computer froze and my mute button came.
Ms. Thomas, you're still with us. Ms. Butler, it's my understanding that in case 22 CR 001112F, you wish to plead guilty to reckless conduct. And in case 22 CR 007278F, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation? You've
I
been
didn't understand. I'm sorry.
Ms. McLeod has helped you out with this case. Are you happy with what she's done to help you?
Oh, very happy, sir.
Okay. You understand that you have a right to a trial by jury on this charge, and that by pleading guilty these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anybody forced you to plead guilty?
No, sir.
I'm going to accept your pleas as negotiated, Ms. Butler. I'm going to waive the probation fees for you while you're on probation. And as soon as you get the anti-theft course done, the probation is going to terminate, okay?
Yes, Your Honor. Thank you.
Oh, you're welcome. And Ms. McLeod, or probation, given that she does not have a computer, I believe that this anti-theft course is generally online, isn't it? Is there? I don't want to put her in a position where she's not going to be able to comply because she's not functional. Do you have somewhere that you can have access to a computer, Ms. Butler?
I could go to the library.
Okay, all right, so, yeah, so you're gonna have to go to the, go somewhere to get online to get this done, okay?
Yes, sir.
All right, good luck to you, Ms. Butler.
Thank you.
Have a great day.
All right, Your Honor, may we be excused, please?
Okay, will I see you this afternoon?
Yes, sir. Possibly not.
Okay, Possibly, possibly not. All right. Have a good rest of the day if I don't see you. Who do we have next?
Position 14.
And this is just going to be an arraignment. And this is Mr. McCreary.
Yes, Mr. McCreary.
Good morning, Mr. McCreary. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. You agree to have your case heard by video?
Sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can put your hand down, Mr. McCreary. You have been charged in case 22 CR 003961G with 3 counts of reckless conduct. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
No, Your Honor, we've read it.
Okay, so my question was, do you waive formal reading? So that's a yes?
We do waive formal reading, yes.
Okay, all right.
Right.
How do you plead, Mr. McCreary, guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you, Your Honor.
Okay, so we still have a number of positions to hear this morning. And let me see, I believe that Ms. Watson Cafe represents position number 29, Ms. Sneed. She is requesting that she's going to file a waiver in this case and that it be returned to Judge Porter for jury trial. That's on position 29.
Your Honor, if I may interject, position 20, I have spoken to her main lawyer and I don't need Ms. Reese today on number 20. We could reset that to some unspecified as yet date.
Do you want to reset it for a state all-purpose calendar, Mr. McLean?
Let's put it at least 2 weeks out because the cases are related and he'll be researching those.
Maybe after the holidays, so it'll be November the 29th.
November 29th, reset.
Very good. I'll make a note of that.
All right. So I've got down that we still need positions number 9 and 10. Now we've done 10, so.
9 and 10 are together. That was done.
9 and 10. Position 25.
Position 25 is conflict attorney, Ms. McLeod.
Are you still with us, Ms. McLeod? Yes. So
I am, Your Honor.
all right, so we're waiting on position 20, your client also.
Judge, it looks like 25 made bond.
25 made bond? Okay, so released.
Great.
And what
25
about
is Roger?
Rogers?
Position 25, right?
Yes.
Yeah. Don
Okay.
Janae Rogers. Yeah, it looks like she made bond.
Okay, and what about position 4 and 5 on the add-on calendar?
That, Your Honor, is Mr. Ephraim, let me find that, Mendoza. And we need to reset that to, it's also number 16. So we need to reset that at least 2 weeks. He needs to speak with a specialized area of law attorney. And he can accomplish that during that time period.
Okay, so we're resetting that till is that the 29th, Ms. Lewis? Reset that till the 29th.
November 29.
Yes, okay. And aside from position 25, I think that takes care of everybody's. Am I missing anyone? Okay.
Did we already go over the calendar, Judge?
No, we haven't gotten quite that far yet, Ms. Helen. Let's see. I just want to make sure that someone from the jail is getting us position 25. Do we still have anyone from the jail that's on with us? Is anyone in courtroom 2? Mr. Jordan, would you mind making?
Sorry, Judge, 25 is the one that made bond, I'm sorry.
Oh, 25 make bond?
Right, Roger.
Yes, Your Honor, she did.
Okay.
Oh, not,
Okay.
okay.
Okay, right. So does that take care of everybody then? All right, so let's go over the calendar so that we can make sure.
Okay. Everybody can hear me?
Yes, we can hear you.
Okay. I don't know who Jonathan Morris is, but can you please keep yourself mute? All right, I will start with the add-on counter. Position number 1, 2, and 3 is going to reset further notice and return back to the original judge assignment, Judge Edie. Position number 4, 5 is going to reset back to the SAP for November the 29th. Position number 6 and 7 is reset for jail jury. Further notice, defendant was arraigned on position number 7. Position number 8, defendant was arraigned in case is reset to jail jury. Further notice. Going to the original counter. Position number 1 and 2, defendant was arraigned. The case is reset for jail jury. Further notice. Position number 3 was a plea and was a global solution with position, it's not on the counter, but it's case number 22CR007278F. Also, she entered a plea on that case. Position number 4 is going to be reset for SAP November the 15th. East Spanish interpreter for the victim. Mother, I guess, or the mother, I guess, of the case. Position number 5 is reset to the competency counter for December the 1st. Position number 6, reset for SAP November the 15th. Position number 7 was a plea. Position number 8 is reset for the competency counter for December the 1st. Position number 9 and 10 was a plea. Position number 11 was a plea. Position number 12, reset for the competency counter for December the 1st. Position 13 was a plea. Position number 14. this is. Position number 13, I'm sorry, was a plea. Position number 14, defendant was arraigned. Cases reset for jail jury for the notice. Position number 15, cases reset for the notice. The case was, the bond was modified to 7,500 signature bond through the jail. Position number 16, reset for SAP November the 29th. Position number 17, defendant was arraigned. The case is reset for jail jury for the notice. Position number 18, defendant was arraigned. The case is reset for jail jury for the notice. Position number 19 was a plea. Position number 20, reset for SAP November the 29th. Position 21, reset for the competency counter December the 1st. Position number 22, defendant was arraigned. The case is reset for trial for the notice. Defendant received a modification of the bond of a $5,000 pretrial through pretrial per judge. Position number 23 was a plea. Position number 24 was a plea. Position 25 was released. The case is reset for the notice. Position 26 and 27. 26 was a plea. 27, defendant was arraigned, not guilty. Case is reset for trial for the notice. Position number 28, reset for SAP November the 15th. Position number 29, defendant waived arraignment. Case is reset for trial for the notice back to the original judge. Position number 30, defendant was arraigned. Case is reset for trial for the notice. Position 31 was a plea. Position 32, reset for SAP November the 15th. Position 33 and 34, defendant is reset for the misdemeanor mental health court for November the 10th. Position 35, defendant, it was a plea. Position 36, defendant was released for the notice. Case is reset. Position 37, reset for SAP 15. November 15, sorry, if I'm not being clear. Position 38, defendant was arraigned. No, I'm sorry. The case was a plea. Took a plea. Was arraigned first. So that case was a plea. Position 39, defendant was arraigned. Case is reset for trial for the notice. Position number 40, defendant was arraigned. Case is reset for trial for the notice. He received a $5,000 good bond. Position number 41 was a plea. Position 42 was a plea. Position 43 was a non-negotiated plea. And that completes the count. Any questions, concerns? Please make sure you send all your non-cross orders to me in a timely manner.
Did the add-on? Did the add-on?
I did, that was the first one I did.
I'm sorry, I have one thing with positions 4, 6, and 37. That's all the same defendant, so if those could be placed on the same calendar.
They are. I love it.
You said 11/15, and then one was 11/29.
Mr. McLean, this is yours. This is what you had on your announcement, and you changed it to November the 29th, I think.
11:15 is fine. It is the same person. I'm gonna get with the state about, you know, the name and the program.
I mean, all his cases will be counted together. I was just going by the announcement, but I thought it was 11:15. For Mr. Velazquez?
Correct.
Yeah.
November the 15th.
Okay.
I had it on November 15 on all of them.
November 15th, right? Okay.
Yeah.
Is that enough time, Mr. McLean?
Yes, Your Honor. The nature of the program is not as crucial as the anti-theft class that the state is asking for. I think we're going to get together on a plea.
Okay.
And
very
is
good.
that the one you need a Spanish interpreter that same day?
Yes, to the extent I believe the mother would be useful in court, we need a Spanish interpreter.
Okay, that's what I thought.
He speaks English. His mother has less English than him.
Okay. Was there any other questions or concerns, Mr. Sarver?
No, nothing at this time. Thank you.
So everybody's clear on the reset dates.
Yes.
Okay, I appreciate that. Please make sure you get your paperwork to me in time enough manner. Make my day really light. Appreciate it.
Thanks.
Ms. Lewis.
All right. We'll see you next week. Have a good afternoon.
Thank you, Judge.
Thank you, Judge.
No.
Thank you.
Thanks.